Court is calling 2021 CR 10313, State of Texas versus Matthew Snow. Could I have parties announced for the record for the state?
Oscar Salinas.
Defense.
Clarissa Fernandez Pratt for Matthew Snow.
And are you Mr. Snow?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Slow, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, next I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonition. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated assault, serious bodily injury? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does. Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he is.
Mr. Snow, I'm going to. Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain agreement, did you review that with your attorney? Did you understand it?
I did, Your Honor.
According to the plea bargain agreement, there's $1,000 fine. State recommends deferred adjudication. They will take in consideration county court cause number 6888355. There's to be restitution to Timothy Knox, Knox, and Storm Buscher, Buescher. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
To be filed, we haven't heard. Thank you.
Then I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 4 years, that there be a TAP evaluation, and no contact with Timothy Knox and Storm Buscher. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Until the offense is charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence to support the plea?
Yes, Judge. State Officer within Marcus States Exhibit 1 and its attachments and evidence.
No objections from the defense.
Mr. Snow, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
I believe so, Your Honor.
All right, anything you wish to say on behalf of your client?
No, Your Honor, this was a one-time incident. With respect to the incident that night, he is very remorseful for what happened. He certainly didn't intend to cause serious bodily injury, but that was the result of what his actions, how he hit the gentleman's face.
So I'm trying to figure out why this happened. So you're at a bar and I'm reading that there was a female who was dancing and the police report says erotically on the dance floor. And then you charged the group. Was this female who was dancing? Was that your girlfriend? What was she to you?
Your Honor, it was my wife. She wasn't, it wasn't erotic.
Well, that's what they said.
Yes, Your Honor.
I'm-
Okay, well, yes, Your Honor, but they were harassing or like bullying. It wasn't like anything like that. Nah. I made the stupid move to defend my wife with violence, and then a fifth guy jumped in to break up the fight. In that moment, I thought he was participating in the fight, and I heard him, and I look forward to the opportunity to make that right through restitution. And
All right, so were you drinking?
no, Your Honor, my tab that night I think was $8.
Do you have any children?
Yes, Your Honor.
What are their ages?
I have 11-year-old twins.
Well, you should know the answer to this question. What's their date of birth?
February 29th, 2012.
Oh, okay.
Mhm.
Usually you'd be surprised. A lot of people don't know the birth dates. So are you employed?
Yes, Your Honor.
What do you do?
I'm a site superintendent for a general contractor construction firm.
All right, any drug issues?
Not at all, Your Honor.
All right, any other questions?
No.
All right, this is what the court is going to do. Oh, I'm sorry, one more thing. This Timothy Knox and Storm Boucher, that's the no contact is outside the agreement. I'm assuming you have no problem not having any contact with them.
I have no idea who they are.
Okay. So we're gonna do $1,000 fine. That will be probated. 4 years deferred adjudication. Taking consideration, County Court Cause number 688-355. Restitution and no contact with Timothy Knox and Storm Boucher. Brenda, I will mispronounce that name several different ways. Are you and your wife still together
No, we're currently getting divorced.
because of this?
No,
Okay,
mental health issues.
all right. So I'm gonna do 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that. If you do that, 40 of those hours be waived. We're gonna do parenting classes. And once you complete the parenting classes, the remaining of the community service hours will be waived.
Okay.
And to me, you can never have too much parenting classes. They don't give you any of that when you leave with your baby at the hospital. As people know, they're just like, here you go, good luck to you. So we're gonna do that. We're gonna do random UAs probation. If there's an issue with his UAs at any time, then do a TAP evaluation. And we'll follow the recommendations for TAP, but if TAP wants inpatient treatment, we'll do intensive outpatient treatment to begin with. We're gonna do field visits 1 time per month. And you do the field visits for 3 months. If there are no issues with field visits, then you can cease them if probation wants to cease with the field visits. And if probation wants, the field visits can count as reporting. But I am going to order regular reporting by Zoom or in person And we'll do an anger management course. Proof of employment within 30 days. There should be no employment as a home health care provider or with minors. Probation, is there anything else that's needed?
No, Your Honor.
Mr. Snow, is there anything else you need from the court to be successful?
No, you're right.
All right. I appreciate you. You always come dressed appropriately for court and you're always on time. I appreciate that. I'm sure your attorney has something to do with that. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you. Your Honor.
Probation, just remaining court probation will speak with you. And do you have that dismissal form?
Yes, Judge. May I approach?
Yes. Court is calling 2022 CR 3922, State of Texas versus Johnny Paniagua. Could I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Tony Jimenez.
And are you Mr. Paniagua?
Yes, ma'am.
All right, you entered a plea of no contest to count one on October 4th. It was set for a PSI. Then it was set for sentencing on November 10th, but we're here now because, of course, we had jury trials and some other things. Have both parties had a chance to review the PSI report, state? Defense?
Yes, Your Honor.
Any objections to the PSI report, state?
None, Your Honor.
No
Defense? All right. Are there any witnesses, state,
None from the state.
defense?
No, Your Honor.
All right, then the court will hear argument. State?
Judge, just a brief argument. We are asking that you deny his application. As you can see from the PSI, he is already a habitual offender. Additionally, the defendant is in custody today because he picked up a new offense, I believe on December the 5th. He was arrested for a new drug offense. Obviously, he's not a good candidate for probation, so we're asking that you deny his application.
All right, defense?
Judge, understanding the reality of the pre-sentence report, what's contained in the report and my client's criminal history, I still wanted to bring to the court's attention that prior to his arrest this weekend, he had completed a drug and alcohol awareness class. He had submitted diagnostic drug testing for the last 3 weeks, which were all negative for methamphetamine and amphetamines. He also attended AA and NA during the period of September 28th up until November 15th. He was to provide me with some additional NAAA class completions, but again, because of his recent arrest, he was not able to provide that to me. Judge, he acknowledges what happened this weekend. We were all shocked by it, myself included, as his attorney of record. His family is really at a loss. Again, he's taking responsibility. It's my understanding that when we go forward today, the state is going to TIC the new case for which he was arrested.
And what was the alleged amount of drugs in the new case?
Judge, if I remember, it came in as a 4,200. We looked at the report yesterday. I believe it was 32 grand.
35.91
All
grams.
right, so here's the thing. When I was an attorney in treatment court, what we would always say is that the difference between a person who's charged with possession and a person who's not is the person who's charged with possession for less than a gram didn't get a chance to use it because they're in the throes of their addiction. But his amount of drugs, the weight of it goes beyond possession in the court's opinion. So I'm going to deny the applications. I'm going to find you guilty. Does anyone want to speak to the cap?
Yes, Your Honor. Well, the state.
Judge, we're asking for 10.
All right, defense.
Judge, I'm requesting a sentence of 6 years in this case, and I'm basing that recommendation to the court on the fact that he has been trying, he was making inroads into his addiction problem. He was in these programs. He was seeking resolution, but unfortunately for him, he made the wrong decision, obviously. And again, I'm just asking the court, I think the last sentence that was imposed on him, I believe was a 6-year sentence. I'm asking for the same sentence in this court. I think that, well, he could speak for himself. I'm not going to tell the court that I believe that he's turned the corner on the situation he finds himself in. But if he wants to address the court on that and why he should get 6 years, I'm sure that he can. But again, Judge, I presented what I thought would be mitigation for him in terms of punishment. And that's all I have to offer at this time.
Is there anything you wish to say, Mr. Paniagua?
I was just trying to.
Just one moment before you speak.
Yes, ma'am.
I'm going to have you sworn in, and if you decide to speak, then the state may have some questions. So do you want to be cross-examined by the state potentially?
Man.
All right.
Yes,
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right, you can lower your hand, state your name for the record.
Johnny Paniagua.
All right, make sure you speak up.
Oh, Johnny Paniagua.
All right, so here's my question.
Mhm.
What punishment do you think you deserve?
I believe, I guess, what you offer. I mean,
I'm sorry, what?
What you offer. I mean,
No. It's like, my question is, what do you think that you deserve?
What would I want?
No, not what you want. Like, I can tell you, usually what people want, they're like, I want probation. But my question for you is, what do you think you deserve? Your range of punishment is 5 to 99 years or life of prison, right? That's the range for the offense. Now, your punishment based upon your plea agreement has been capped at 10 years.
Yes, ma'am.
So I can sentence you anywhere from 5 to 10 years.
Yes, ma'am.
So my question is, what do you think you deserve?
I will go with 6.
Why? Why do you think you deserve 6 if you just spent 6 years in the prison?
Because I've been trying to change. I've been my hardest. I've been trying to give up everything. It's just I made a wrong decision at the wrong time, just because I was trying to save up some money for commissary or my daughter right at the end too. And I know I messed up.
Well, here's the thing. If you're telling me you're saving money for commissary, then that means that
No.
you're selling.
No, like for my daughter.
Well, that means that you're selling. And you're not just using. And I'm going to tell you what I tell plenty of people who have drug addictions, plenty of people who sell drugs. You know what my grandmother and mom always told me? You can't build your happiness off somebody else's misery. And when you sell drugs to people, they're in misery and you're trying to build your happiness, your financial happiness off their misery. And that's not good. You understand?
Yes,
Just
ma'am.
because you're hurting, that doesn't mean that you should go out and hurt others.
Yes, ma'am.
You see people on the side of the road who are addicted. Some of them, their mind will never be the same because of whatever drug somebody sold them, who is building their happiness off their misery. And at the end of the day, I bet when you get the money, you don't even know where it went because it goes so quickly because you didn't get it in a good way. You understand?
Yes, ma'am.
All right. Is there anything else?
Nothing, Your Honor.
All right. This is what the court's going to do. I'm going to find you guilty. There's $171 restitution to SAPD, taking consideration 2022 CR 6572. Do you want to be placed in the therapeutic community?
Yes.
All right. So here's the thing about the therapeutic community. They may not accept you, but they definitely won't accept you if you don't request it. I can't order them to do it. I can just request that you be placed there.
Yes, ma'am.
So we'll do the therapeutic community, 8 years in the prison, and give you credit for any time served. Is there anything else with regards to sentencing?
Nothing, Your Honor.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Mm.
Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. State, do you have the dismissal on that?
Yes, sir.
Thank you. You're welcome. All right, thank you.
Judge.
Always good seeing you.
Yes, sir.
Matthew Snow stood before Judge Boyd, facing a second-degree felony charge of aggravated assault, causing serious bodily injury after a violent confrontation at a bar. According to court records, Snow rushed toward a group of men he believed were harassing his wife and, in the chaos, seriously injured another person who had stepped in during the fight. Snow admitted he made a terrible decision and expressed remorse, explaining that he acted out of emotion while trying to defend his wife. After reviewing the evidence, Judge Boyd acknowledged the seriousness of the injury, but also considered Snow's clean presentation in court, stable employment, and lack of substance abuse issues. Instead of sending him to prison, the judge placed him on 4 years of deferred adjudication, ordered restitution, community service, parenting classes, anger management, and strict probation conditions, warning that any violation could result in a prison sentence of up to 20 years.